was a specific case, my lord, that no dearness allowance is payable. But my lord, their agitation now also includes, my lord, that 3%, which is, my lord, now another further 3%, 6%, saying this is not what should be granted as by way of dearness allowance. They're pressing for a higher, my lord, rate. There your lordship said, my lord, there your lordships indicated if we could have, my lord, a negotiation on that. Because in Supreme Court, what's in the Supreme Court, my lord, it's there, my lord.
Yeah, that's why we pointed out last occasion. There are two issues.
Correct.
One is ideas.
Correct.
Second is percentage.
Yes.
And they were saying that this is the only state in the country where the dearness allowance is a single digit dearness.
Correct. So
That is what they are agitating. So probably when you sit for a dialogue, you can have a clear demarcation. The arrears, etc. issue is there. Whether any revision of the percentage.
Yes, my lord, that's my lord, where, my lord, I thought, my lord, there could be, my lord, negotiations, and my lord, if they,
Because the neighboring states are all on double digit.
my lord, that's one side of the
It
picture.
is up to the government.
No,
We
my
can't
lord,
say you fix at
no,
that.
my lord, not just that. My lord, there are several other things other than dearness allowance. My lord, we have to look at, my lord, the financial package, my lord, at the end of the day. So, my lord, I believe, my lord, negotiations will help in, my lord, understanding each other better. But, my lord, this is only with regard to rate. With regard to, my lord, arrears, my lord, what has happened is before the Supreme Court now, my lord. So, my lord.
So you have an open dialogue.
Yeah.
For the present, we have requested them not to precipitate the issue. We will make some observations in this order, and this will come.
Let's come to page 37.
Arre, chhede ding, my lord.
You have pointed out an issue, leave it to the court, we will pass an order. If you are not satisfied with this order, you take it through.
The order was issued by Finance Secretary Manoj Pant on Saturday. A bureaucrat said on
We know about it, sir. We know about it. Before even you file the writ petition, part of your affidavit is published in the newspaper. So when morning, everybody will read the newspaper. What is
I want to say only one thing, Lordship.
Ye notice pe jabe tumra.
I am asking myself, what is the relation between DA or siege war, pen down,
No,
or any other age?
that's a form of protest they are showing. They say it's a peaceful protest. I am entitled to do that. You cannot prevent me. You have rightly highlighted that what is the prejudice caused to the entire society on account of this one day ceasefire. Well taken. Well taken. There's no issues.
My lord, only one thing, my lord. With regard to ROPA 2019, there is no litigation pending, my lord.
There is no question at all.
We are also not getting the benefits in terms of ROPA 2019. That is also one of the.
That you sit for a dialogue.
Yes.
By this writ petition,
They are saying all time.
petitioner,
support it.
a practicing advocate of this court, has sought for issuance of a writ of mandamus to direct the fourth respondent to prevent the implementation of a bandh called on 10th March 2023 and 6th April 2023. The petitioner appearing, the learned, sorry,
Lordship, 15th March.
pardon, your prayer is
15th March.
15th March 2023 and 6th
And
April.
6th April.
Your prayer says 10th March. The petitioner appearing in person would submit that on account of the strike call given by the fourth respondent, Federation of Employees, the innocent public are put to great prejudice, and it would cause and has caused great economic loss to the state, which cannot be compensated. It appears that the fourth respondent federation has given the call for conducting a cease work on the aforementioned dates, highlighting the main issue with regard to the dearness allowance. On the last date, that is on the last hearing date, namely on 6th April 2023, when the matter was heard, we suggested to the Learned Advocate General that the state government can consider inviting the office bearers of the Fourth Respondent Federation for a dialogue. However, on account of no staff members reporting for duty on the said date, we were unable to pen down an order on 6th of April 2023. However, the Learned Advocate General was fair enough to state that no written orders are necessary and he will do the needful in the matter. When the case is taken up case was taken up today, the Learned Advocate General had submitted that the state will hold a dialogue with 3 nominees of
No,
the
my
Fourth
lord, it's
Respondent.
become, they have, my lord, increased it after speaking to me. They made it 5.
Ah.
My lord, they've given me the name, so it will be 5.
5 nominees of the Fourth Respondent Federation. And on behalf of the state, a committee headed by the Chief Secretary of West Bengal will be constituted and the date will be fixed for conducting the dialogue. The office bearers, Mr. Bhaskar Ghosh.
Yes.
Mr. Bhaskar Ghosh, not office bearer. Mr. Bhaskar Ghosh, convener of the Fourth Respondent Federation, is present in court. This court made certain observations as to how the seize work, which was conducted on 15th March 2023 and 6th April
My lord,
2023.
My lord, it should be 10th of March. My learned friend's incorrect. The prayer is correct.
Prayer
It's
is
10th of March.
We also, sir, it is only 10th of March, not 15th. 10th of March 2023 and 6th of April 2023 had affected the functioning of this court, not to say about the other officers of the state government. The learned advocate appearing for the writ petitioner submitted that the government has issued an order that the employees who do not report for work will lose their salary and their absence will be treated as break in service. We are not here to make any observation in this regard, and it is for the state government to act in accordance with law. We have reasoned out to Mr. Bhaskar Ghosh, the convener of the Fourth Respondent, that the issue relating to the dearness allowance is now pending before the Honourable Supreme Court in an appeal filed by the state of West Bengal against the judgment of the Honourable Division Bench of this court. And it may not augur well for the Federation or its affiliates to give a call for a pen down strike or cease work, especially when the matter is sub judice before the Honourable Supreme Court. We hope and trust that this observation made by us will be taken in the right spirit by the Fourth Respondent Federation. Without prejudice to the rights of parties, the representatives of the Fourth Respondent Federation are directed to participate in the dialogue with the state government in with a committee constituted by the state government headed by the Chief Secretary of the state. And this dialogue and whatever discussion is being made during those proceedings will not in any manner impinge upon the rights of the employees or that of the state government which has filed the appeal before the Honourable Supreme Court. The state government shall fix a date for the meeting within 10 days from date and intimate the intimate the convener of the Fourth Respondent so that 5 of its nominees can participate in the meeting on the date, time and place fixed by the Chief Secretary of the Government of West Bengal.
My lord, only one thing. My lord, the request, my lord said, my lord, the chief secretary as well as finance secretary should be there.
We,
Your
we,
lordship,
we said, say chief.
very well, my lord.
Lord, most humbly, may I submit on your lordship knows, my lord, in the West Bengal service rules, my lord, right to strike, we have a right to strike by your
We have,
lordship's
we-
observation.
even before you told, we have told the advocate general.
No, my lord, only one thing, with deepest of respect, my lord, most humbly, my lord,
We have not said your style, you.
no, your
intended.
lordship has said, my lord,
We have only said this observation may appeal to you, that's it.
may
go- it
observation,
doesn't,
your lordship's observation is a direction upon us, my lord, we are bound by it. There is no
No, no.
question about it.
That
Only
is
one
only-
thing, this will
Direction is,
also,
no, direction is different from
my lord,
observation.
your lordship knows already hundreds of show cause notices has been issued for break-in service and some of them have been implemented. If this observation, my lord, will also be, they will take this in those proceedings and it will
No,
also
we said-
hamper.
No, so with regard to the notice,
Yes, my.
which you said, we said we are not making any observation in that regard.
And my lord, only one line subject to your lordship's convenience, my lord. Those
We make it clear.
proceedings will not be affected.
The learned advocate appearing for the fourth respondent federation submitted that the observation made by this court should not be taken to be a direction on the state government. Full stop. We are clear in our mind that we have not issued any direction. And we had only recorded the submission made by the petitioner, pointing out an order passed by the state government. And the observation made by us to the fourth respondent federation was to the effect that we hope and trust that the observation would appeal to the fourth respondent. This clarification is issued in the light of the submissions made by the learned advocate for the fourth respondent that right to conduct a peaceful strike is a fundamental right in terms of the relevant rules framed in this statement. Yes,
Lordship, may I
Thank
say
you.
one thing?
this post of.
One of my learned friends said, continuous siege work and continuous
No, that he will next. Please call.
could not be tolerated.
Next. Item number 7.
Item number 7,